morning. The YMCA Education Series is free and open to the public, so we encourage you to spread the word and invite family and friends to participate. We host approximately 8 to 10 of these a month, varying in all topics. The program will last about an hour. You might find that you have questions during the presentation. We'll be happy to address them at the end of the program. When you have a question, actually for today, because it's Q&A, we'll listen to what Matt says to do as far as questions and answers. The chat box, though, if you do want to ask me a side question, or Matt and I a side question, feel free to put it in the chat box. We will answer those throughout the program. Thank you again for joining us this morning. And I would like now to introduce Matt Margolis. And he's going to be talking to you about elder law Q&A today, about who likes free advice. Free legal advice doesn't come around too often, but our favorite attorney, Matt, will be answering questions for a full hour, maybe a tad more if we convince him. Just make sure you're comfortable with the crowd, and this will not be a one-on-one Q&A as much as a public forum in front of all of us. So thank you and welcome, Matt.
You're welcome. Thank you, Pam. All right, so I think I know one of the two people that are attending today. So maybe there's only one person that I don't know out of the four squares here. So for that one person, just so you know, my name is Matt Margolis. My partner Lauren Weldon and I have a boutique elder law and estate planning practice in downtown Park Ridge. We help people of all ages, for the most part, starting at age 18, with their estate planning and elder law needs. So we do powers of attorney for 18-year-olds going off to college. We do wills, trusts, powers of attorney, special needs planning, asset protection work for people of all shapes and sizes and ages. And then on the elder law side of our practice, we have a strong focus on helping people protect assets and apply for Medicaid, and just really act as a general resource or sounding board for those families that are dealing with a loved one going through a transition later in life, and really just trying to help them and support them in whatever way we can, even if we're not the best fit. And it's just about connecting them with other resources that can help them. So that's who I am. I'm married. I've got 2 little kids. I live in Northbrook. I was a Y member at one time for quite a while, and then the pandemic hit, and now I work out in my basement. So that's me. So today is Elder Law Q&A. I really had 0 agenda. And so, as far as I'm concerned, today's talk might be 15 minutes and it might be an hour. And so ultimately, I'm going to leave the floor open. And I'm presuming that if you're attending this today, you have some questions. If you don't, I might just find a couple things to talk about briefly. But I'm quite busy, so if there's no questions, then we can all sign off and hop on the next month's call. So without further ado, anybody who's on here, feel free to unmute yourself or type a question into the chat box, and I'm happy to entertain your questions.
Good morning. Can you talk about power of attorney?
Yeah, love to. So is it Iwa or Eva?
It's Eva.
Eva, okay, neither one. So thank you. All right, so Eva, powers of attorney. So in Illinois, we have 2 types of powers of attorney documents. Okay, so we have a healthcare power of attorney and a property power of attorney. And the healthcare power of attorney is where, and these are separate documents. I want to be very clear. Okay, these are not the same documents. So separate documents. The healthcare power of attorney is a legal document where we're naming somebody to make medical decisions for us in the event that we can no longer make our own decisions. All right, and so we can name as many people as we want. And I can name 3 people, I could name 5 people on this document, but they can only act one at a time. Okay. Of course, not all of my clients like it when I tell them that, because inevitably they want their 2 children to be able to make decisions for them together. But Illinois says we only want one person at a time. So while I can name my wife and then my brother and then my sister and then my mom and then my dad and then my best friend, I have to figure out the right order to name them in, right? Who do I want? who is the first person that I would want to step in to make medical decisions for me? And if he or she couldn't do it, who would be the next person? Okay, so I have to list them in order. That doesn't mean that if I'm naming my, my youngest daughter, it doesn't mean that she can't communicate with her brother, right, my son, and that they can't talk about things. And then ultimately, she's the one that relays, the decision to the doctor, right? It doesn't mean that they can't communicate. It just means that I can only have one true decision maker, okay, at a time. And listen, I think it's good that Illinois does this. I believe, and I probably should check into this, but I know that at least one point in the last 5 years, Indiana allowed, and there's other states that allow you to name co-agents, 2 people at a time. I really don't like the idea of that. I understand that people would love their maybe 2 people to be able to step in and make decisions, but what if a pretty serious medical decision has to be made and we don't have a lot of time to make it? The last thing I want is 2 people to be fighting or disagreeing about what decision has to be made for mom or dad or whoever they're making it for. So I support the one at a time. I like that Illinois does that. And so again, we have the healthcare power of attorney in place so that somebody can make decisions for us from a healthcare standpoint when we can no longer make our own. The other power of attorney that we have in Illinois is a property power of attorney. Okay, and a property power of attorney is who can make decisions for me with respect to everything that's not healthcare related. Okay, so it's not just property like real estate, which a lot of people think, right? There's a lot of people that I meet with, and I say property power of attorney, and they say, oh, well, I rent an apartment, so I don't need a property power of attorney. That's not correct. Okay, so a property power of attorney is not just relative to real estate. A property power of attorney deals with all decisions that are not medical in nature. Okay, who can sign a contract on my behalf? Who can access my bank accounts or my IRA or my life insurance policy? Who can deal with my real estate? Okay, so any real estate I own, they can deal with my real estate. Who can deal with issues that arise with Medicare or sign a Medicaid application for me, file my tax return with the IRS. These are all things that my property power of attorney would step in and manage. Okay, similar to the healthcare power of attorney, I can name as many people as I want, but it's one at a time in a particular order. If I becoming, and the whole point of these documents, just to be very clear, number one, I shouldn't say obviously, but if I'm incapacitated or anybody's incapacitated, we need somebody to make decisions for them, right? I think we would all agree. We need somebody to make decisions for them. But the reason why these documents are so important is Illinois doesn't just allow anybody to step in and make medical decisions for an individual who's incapacitated. They need a power of attorney. And there's no default. It's not like, oh, hey, Bank of America, I am Christina's husband and she's incapacitated, and so you need to let me deal with her retirement account, her IRA on her behalf. The bank would say no way, right? And so really what we're looking to prevent and what we're looking to avoid is going through a guardianship. All right, if I don't have powers of attorney in place and I become incapacitated, the only way that somebody's going to be able to start dealing with my bank accounts or sell my house or sign a Medicaid application for me or file my tax return is that they're going to have to hire a lawyer, go to court, go and obtain guardianship over me. Okay. It's not that a guardianship is the end of the world, but a guardianship, realistically, even on the low end, you're probably looking at a couple $1,000s in attorney's fees and court costs to obtain a guardianship. And then really what's not ideal is that depending on the decisions you're looking to make, moving somebody into a nursing home, selling their house, there are certain things where you have to actually get court approval, as crazy as that sounds. And so really we can avoid all of that by putting powers of attorney in place. Okay. And powers of attorney, to me, everybody over the age of 18 should have powers of attorney. This isn't a quote unquote old person document, because once we all turned 18, we became the only person in the world that could make decisions for us. Okay, before we were 18, our parents did, or whoever our legal guardian was. Okay, that person was able to make decisions for us. But once we turned 18, we are the only one that can make decisions for us. And in order for somebody else to do that, we need a power of attorney. And if we don't have that, we need to go through a guardianship. And I can tell you that a power of attorney is going to be much less expensive and much less hassle over time. So good question. Ava.
Matt, I know you've talked about this before, but then how do you, so I'm over 18, right?
Yeah.
And and I live with my cat. So I'm like, oh, okay. I know you've talked about this before, but then how do I go forward with figuring out how to have a power of attorney?
So are you talking, so Pam, is the question how to put one together or who to name?
I mean,
Or neither.
or like paperwork, like I contact you or a
Oh,
lawyer,
yeah.
like,
So,
or
yeah. So, you know, there are different ways to put powers of attorneys together. Okay. I'm gonna be more of a fan of certain ways, but if we're talking about different ways that you can do it, I mean, people can print these documents online. I do not recommend that. Okay. So while I'm saying that is an option, I don't recommend it, only because if a power of attorney is, first of all, you may not be finding the most recent one, right? So the powers of attorney in Illinois change over time because these are statutory documents. Statutes are changed over time by the lawmakers. And so first of all, you might have an old form, it might be outdated, and you may not be executing it appropriately. And so I've had clients come to me where they signed a power of attorney on their own, and they come to me and ultimately, so just so everybody's aware, in Illinois, a healthcare power of attorney has to be witnessed by one person. Okay. Typically in our office, if we will have two witnesses, but it only legally, to be effective, it only needs one witness. And then a property power of attorney needs a witness and a notary. But a couple things happen, right? So inevitably, in some cases, people do it on their own and they don't have the property power of attorney notarized. Or what we see all the time is that the witness who signs the power of attorney is a family member. Okay, and a witness cannot be related to the person signing the document by blood or marriage. And the witness cannot be somebody who's named in the document. As we're saying this, I literally had a meeting yesterday afternoon with two women and their father. And their mom, unfortunately, had a stroke a few months ago, and they had mom sign a healthcare power of attorney in the hospital. And who was the witness? One of the daughters.
oh no.
Right. And of course, they said, well, nobody told us we couldn't do that. And then my response was, you signed in a hospital. These aren't, I mean, nothing against them, but they're doctors. They do a great job of taking care of people. They're not lawyers. That's not their specialty. And so they basically have a power of attorney that's totally ineffective. And this is the same when it comes to clients that will go online and, put together wills or trusts and do that on their own. The problem when people do it on their own, even though they can't, is that if they do something wrong, then they have a document that they believe is going to help them, and it's not, because it's not an effective document. So honestly, while people can do it online, and I think in some cases you can actually buy these forms at like Staples or Office Depot, I really don't recommend that. I would say this is one of those things where you go to a lawyer, and whether it's me or somebody else, I really don't care, but go to a lawyer who concentrates their practice in estate planning, or if you're an older individual, probably do meet with an attorney that doesn't just do estate planning, but does elder law as well, because there's just other considerations that we have and that we put in our documents. But this is one of those things where think about it this way, right? I think there's certain things, and this kind of goes, this is a bigger conversation, but there's certain things where it's good to be like a bargain shopper, right? Or certain things where it's okay to do it, DIY and do it yourself. Putting a document together, putting a legal document together where it's going to allow somebody to step in and make decisions for you in a situation where you become incapacitated and you can no longer make decisions for yourself, very likely for the rest of your life. This probably isn't a situation that we should probably be doing it on our own, or being a bargain shopper and trying to find the cheapest attorney that we can go to, right? Because we might end up finding ourselves going to the lawyer who pretty much does divorce work and real estate work, but yeah, sure, they'll slap together a power of attorney for you. So yeah, again, I don't care if it's me, but meet with an attorney like me who looks different than me, and do it with that attorney, because this isn't something that you really want to screw around with. So I know I talked in circles there, but believe me, I'm telling everybody, I say this and I'm passionate about it because I've had so many clients come to me where they try to do it on their own, or they, had a family friend who's a lawyer who doesn't really practice in this area help them. And sure enough, mistakes were made. And what you don't want is to think you have a power of attorney that's effective, and then all of a sudden you're incapacitated. Now it's too late.
Yeah.
And now we can't undo the fact that you have a bad document in place. And now it's going to cost a couple $1,000s and going to court to fix it. So.
He also did a nice plug for estate planning, which will be next month's talk by Matt, January 5th.
There you go.
Talk about it later.
Total
I have
accident.
a question.
Yeah.
Now, these witnesses who are not family member who sign, do they have to be alive, or does the state or anyone check that they witnessed, or it's like a witness is a witness on paper?
What do you mean? Are they alive?
What if
I want to make sure.
What if a witness witnesses or signs the document and dies? Does that make any difference?
No, people die. As long as they were alive when they witnessed it, that's all that matters to me. Yeah, but no, it's but not to joke around. Yes, there's nothing we can do about that, right? I mean, I can be a witness for somebody and then I can die 2 years later, and that happens all the time. Especially when I'm looking at clients who signed documents 20 years ago. The witness could have been older or younger and gotten ill. So yeah, there's. I mean, other than it being unfortunate that the person passed away, there's no issue with the witness dying. The biggest issue is that the witness was not related in any sense to the person who signed the document, or was not named in the document. Okay, so even though I'm not related to Pam, if Pam were to name me as her healthcare power of attorney, I cannot also witness the document. Okay, so again, it's not just that I can't be related to the person by blood or marriage. The witness also can't be one of the people that's named in the document as an agent. Okay, so I'm called if somebody names me as their power of attorney, I'm called their agent.
Could you give us a ballpark figure of the cost of making both the power of attorney for health and for property?
I will type my email in the chat box, and you are free to email me that question, but I really don't like to discuss fees. Otherwise, I prefer to keep that separate. So I've got my email there, and you can email me. I'm happy to respond to that question.
Thank you.
Yeah, of course.
Any other questions from the group?
Yes. I'd like to know about living wills and whether there would be any point in my opening a living will. I have only one beneficiary, and I thought it might be simpler if I put everything in one place.
So
I think I'm saying the wrong thing. A living trust.
No, that's okay.
A living
Yes.
trust. Is that what it is?
Yeah. Well, either you're saying a last will and testament or a living trust.
I'm saying a living trust.
Okay.
Would there be any point in making a living trust?
And obviously next month I'll go into more detail in the estate planning talk I give. But the biggest benefit for most people of a trust, of a living trust or revocable living trust, is the idea of avoiding probate. Okay. And so for the most part, and most people don't think that way, right? Most people have no idea about how a trust works. Most of us kind of have this idea that trusts are just for wealthy people. And yeah, the reality is we can use trusts to help avoid estate taxes, but that's a pretty small percentage of the population. Okay. In Illinois, we don't have a taxable estate unless we're over $4 million. And so for most of us, Joan, we're using a trust. I'm not saying that you don't fall into the taxable estate category, but just based on your question, for most of us, the idea of a trust will be to avoid probate and to simplify the administration of our estate when we die. And typically, just by having a last will and testament, we're not going to avoid probate. Okay. And so a lot of times we'll use a trust to do that. Now, if we only have, so in your case, Joan, if we only have one beneficiary, so the question being, does a living trust make sense? it depends. What if that one beneficiary doesn't survive you? Right. So the question becomes, well, if this one person that I'm leaving everything to doesn't survive me, where do I want it to go? And if I maybe want it to go in different directions, or I want it to go to different people, then, and especially if I own real estate, then a living trust might make sense, because, we want to have a backup plan in place, just because, we're leaving money to somebody that, I'll do some presuming here, and I can be wrong, of course, but, just because we might be leaving money to somebody who's younger than us doesn't guarantee that they're going to survive us. And so, I always like to have a backup plan in place. We always, unfortunately, have to ask the hard questions about, well, what if your son or your daughter didn't survive you, or if your nephew or niece or your grandson or granddaughter, if they didn't survive you, where would it go? We want to just make sure that we're planning thoroughly. I'd rather plan for the worst and have, the most ideal outcome occur, versus, trying to just plan very simply, not taking into account that certain things could happen, and then my plan can kind of go by the wayside, and then I could have a situation where something's going through probate. So, I know that I'm not giving you a direct answer, Joan, but it really depends. It goes deeper than just, I've got one beneficiary. It can come down to, what assets are we looking at? Are there retirement accounts? Are there life insurance policies? Do I own a house or a condo? Do I have a second property? And then again, beyond that, what if this person doesn't survive me? Where would I want everything to go then? And then sort of once we know all that, then we can really figure out, what is the most appropriate plan. And maybe we don't need a trust, or maybe there's options, and sort of like, hey, listen, one option is a trust, and the trust is going to do this, this, and this. And obviously these are going to be the costs associated with it. Otherwise, we can kind of avoid the idea of a trust and go in this direction, understanding that there might be more downsides, or might be more negative consequences going down that path if, something maybe didn't work out the way we wanted it to, or the way we planned. And so there really are other factors that we have to consider, basically, to really get a solid answer. But in general, I've seen both. We've had clients do both, where they've got one beneficiary, whether it's their son or daughter, niece or nephew, or brother or sister, whoever they're leaving everything to. Again, we've had situations where we have put a trust together, a revocable living trust, and situations where we planned without one. Obviously, them understanding that it might not be the perfect plan, and a wrench could get thrown in there. But at the end of the day, we just want to make sure people plan and they're comfortable with what their plan is, and as long as they're educated and making an educated decision, that's all I care about. So I hope I
thought it might make it. I thought it might make it easier for a beneficiary to have everything kind of in one place within the trust.
Listen, you're not going to get a disagreement on that from me. This is what I do, and I firmly believe that it makes life easier. But of course, we have people that want to kind of, and I don't mean this in a bad way, but they like to cut corners and kind of do it in their head, like in an easier way and less costly way. And there is that option too. It's just what are we most comfortable with at the end of the day? So yes, I do agree. The trust would make things easier in most cases.
Okay, thanks.
Sorry to go around in circles there.
Any other questions from Matt?
Hi, Matt. I just wanted to ask about what else should we be thinking about? When you talk about elder law, you've mentioned having a power of attorney, a financial as well as a medical.
Mhm.
You talk about a trust, a living will. Is there anything else that we should be aware of that would be helpful for us as we get older?
The biggest thing that we deal with on the elder law side. So, if we're past the point, if we've got our planning done, right? If we've got our wills and trusts and powers of attorney in place and all of those documents in place, and we feel like we've got good documents in place, right? They're up to date. They reflect our current desires and wishes. It's not like these are documents we put in place 20 years ago and now our kids are in their 30s and life has changed and maybe we should make updates. So as long as we've got all of our sort of traditional estate planning up to date, I think the things to consider as we get older are maybe bigger than just from an elder law standpoint. So there's the idea of, and this is not something we sell, so I'm not pitching our services, but there's the idea of looking into long-term care insurance, right? Maybe it makes sense to sit down with somebody, and especially if anybody here has dealt with a loved one in a nursing home or assisted living or memory care, how expensive that is. Okay, these are real dollars being spent, and in some cases, this can be 12 to 15,000 or more a month. And so one thing would be maybe looking into long-term care insurance, just seeing what options are out there, especially while we're, even though we're getting older, while we're still, what I'm going to say, younger, right? So, I've got clients that come to me and they're like, they're in their 60s, and they're like, well, we're seniors and we're older now. And of course, to me, I work with 90-year-olds and individuals in triple digits. So, I still like to think that those 80-year-old clients of mine are young, but being realistic when it comes to long-term care insurance, I mean, if you're in your 50s or 60s or early 70s, it's not crazy to be looking at long-term care insurance, seeing what options are out there. You don't have to buy it, but at least get some education. Understand what your options are. Maybe you're able to buy a policy that has a life insurance benefit to it, so that you're not going to waste it if you never end up in a nursing home, right? Because that's typically people's biggest issue with long-term care insurance, is that they spend a couple $1,000s a year in premiums, and what if they never go into a nursing home, or they never need long-term care? So they waste all this money. Even though on the flip side, my argument to people all the time is, you pay for health insurance every year. And I don't think most of us aren't unhappy if we don't go to the emergency room or we don't have a surgery. And health insurance is pretty expensive, right? I mean, I know my health insurance for my, young family who typically doesn't have a ton of issues is very expensive. And we typically we might bat an eye, but we know that we need it, right? And so really recommend looking into long-term care insurance. And then really from an elder law standpoint, I would say, if we have a concern, so let's say that we've looked into long-term care insurance and it's too expensive, or maybe we have an underlying condition, an underlying medical condition, and we can't get underwritten for the long-term care insurance, okay? Because I've had plenty of clients come to us with that situation where they're young enough, they're healthy enough, they can afford it, but they have some kind of underlying medical condition and they can't get it, right? Just like not being able to get life insurance if you have a certain diagnosis. Then one thing that we can look at is, is there any kind of desire to protect assets, right? So if my wife and I both end up needing long-term care at some point, do we want to do any kind of planning where we're looking at a trust that's irrevocable? And I'm not going to go into tons of detail on it, but do we have a desire to maybe set some assets aside so that, God forbid, one or both of us needs care for an extended period of time, we're not going to impoverish the healthy spouse, and we're going to have some assets that we can set aside, whereby I can still maybe apply for Medicaid to pay for my long-term care at some point, but I'm not draining all of the assets that my wife and I have earned over the course of our lives. So I think those are the two big things, honestly. I think it's really considering that we might have a lot of costs later in life related to our long-term care, and how do we plan for that, and whether it's through long-term care insurance, whether it's through some asset protection planning with an elder law firm. I would say those are probably the two biggest things if we're trying to be proactive, looking into the future. Otherwise, there's really, I don't really have a good answer. I can't think of too much else, right? I mean, to me, it's making sure you've got your planning in order. And then if there's some desire to sort of, protect against long-term care costs down the road, then you can look into, doing some planning outside of long-term care insurance. So I hope that answers your question.
Yes, great. Thank you so much.
Sure.
Any other questions?
Does power of attorney for health transfer if a person moves to another state and they make one in Illinois?
Yes, as long as it was executed appropriately in Illinois, then it will be honored in another state. However, what I will say is, and I tell my clients this all the time, if they do move somewhere, while wills and trusts, I think they should have their wills and trusts reviewed by an attorney in another state, there might need to be slight changes made to the will or trust based on certain laws in that state, but typically the wills and trusts don't need to really be updated a whole lot. I typically do recommend that new powers of attorney are put in place, just because they are very state specific. And those are documents where, listen, if I'm incapacitated, my power of attorney for healthcare, it's going to be used in the hospital and by doctors in that state pretty often. And it's just going to be easier if I have a document that's according to that state's statutes. And so if if my clients move to another state and they have capacity to sign a new one, I typically recommend that they do. Obviously, if they don't have capacity, so, I've got clients where, they're older, they have dementia, and, they're going to move from Illinois to Wisconsin and to move in with their son or daughter, or to move to a nursing home that's close to their son or daughter. Obviously, if they already have dementia, they can't sign a new power of attorney, then the one they have is fine. And in most cases, the one they have will be fine, but it can just make life easier to update them if you do move to another state.
Okay, thank you.
Mhm.
Doing great on questions. Any other questions? All right, Matt, I know you got a lot to do. If no one has any other questions, we can close this out. That's work. Matt, you have any last thoughts?
No, good questions. I'm glad. And I would just want to make everybody aware, obviously, of all the different talks I give throughout the year. So, so we obviously touched briefly on some topics today, but so Joan, if you have any interest, in learning more about wills and trusts, I believe that is the talk in January. And just look at the list. I know that the Y does a good job of getting the information out earlier, and I don't even know if there's a calendar maybe where you can see kind of talks months in advance.
2022, but yes, already our January dates are up. I'm trying to get them up as soon as I get them.
Sure. So, I would just say that, if there's anything that you heard today that you want more information on, just take a look at the calendar, see what's coming up. You can always email me. I put my email in the chat box, so you can email me, and if there's a certain topic you're interested in learning about, I can always let you know what month we're going to be speaking about that in. And also, just so everybody knows, which I've actually never mentioned on this, I do the last Thursday of every month. So I'm kind of pitching a private thing here, but I hope this is okay. But the last Thursday of every month via Zoom, I do an estate planning 101 talk, which is going to be very similar, almost identical to the talk I will do in January through the Y. But the last Thursday of every month, 7:45 at night, I do a talk on wills and trusts and powers of attorney, just very general information. It's free. I don't charge anything for it. Again, it's just meant to educate people, and so if that's ever something that anybody here is interested in, or somebody's interested in, you can always, give them my email. We're just here to make sure people understand, what options are out there.
Matt, and Matt's email's in the chat box, and you can always email me or YES, and we'll get that information to you. All right, everyone. So thank you so much, Matt. This was really informative, and thank you for everyone for asking questions, because that was made the talk today really amazing. Yeah. That concludes our YES Education Series talk. On behalf of the North Suburban YMCA, YES, thank you for supporting our organization and programs like this. Special thank you to Matt for speaking with us today. Programs like this are free and open to everyone in the community. So if you enjoyed today's program, we always encourage you to go support and make a donation at nsymca.org. We look forward to our next speaker on next Wednesday, December 14th at noon, talking about solid nutrition habits for the new year. And then also just to remind you, Matt will be talking on January 5th about estate planning, Wednesday, January 5th, 2022 at 9:15 a.m. once again. And we'll go more into that. So we look forward to seeing everyone then. Have a great day, everyone. Thank you again, Matt.
Happy holidays. You got it.
Holidays.
Thank you so much.
Thank you.
Everybody.
Bye.
Holiday.
Bye-bye.